All right, so you were to think about that and to think whether you agreed or disagreed. And now we'll come to uh, the real issue for the court. The real issue for the court was not whether or not guns deserved constitutional protection. There's, of course, the Second Amendment. Congress shall make no law respecting. That's the First Amendment. The right of the people to peace. The right. All right. Hopefully, you thought about that and thought where you stood and why. Probably many of you considered the Second Amendment, which reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And my guess is some of you obviously thought about that, and that's definitely a consideration. Interestingly, though, for the court, that was not on their radar at all. What the court was really looking at was how much power should the national government have? How much power should they possess? This was a federal question. It was a question about federalism. Did the Constitution give this power to the national government? Did they give it to the states, or did they deny it to them both? And in a close decision, the court said no, the federal government did not give this power to the states. To the national government. Whatever ought to be done, it should be done at a state level, was really where the court was coming down on this. So United States versus Lopez was not a gun control case for the court. It was a case about federalism. And so this idea, going again back to Wilson's statement, it's not settled in one generation. We keep going back to what this means and what should happen. In this case, the Supreme Court, by the narrowest of margins, said no, this is not a federal issue. Or a national issue would be the more appropriate way to say that. Okay, so now I talked earlier in the last video about we're gonna look at these different views about how federalism has played out and been viewed in our system. And the founders themselves walked away from the Constitutional Convention with differing views on how this new government was to work. Not everybody saw it the same. And then there were those who weren't even there who had their own take on what the Founding Fathers had done. For instance, Jefferson was not at the Constitutional Convention. He was over in England trying to settle some issues on trade. But his view came to be embraced by many, and it is known as the state supremacy view, or the Jeffersonian view, or the strict construction view of the Constitution. And this is what those proponents of this view have to say, that the federal government was intended to be a government of limited powers. And as proof of that, they look at the 10th Amendment, and which reads, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So they look at the 10th Amendment and say, look, here's a philosophical statement that says the federal government was never intended to possess certain powers. Then they also can cite that the federal government was a product of the states, and since it was a product of the states themselves are supreme. In other words, how can one entity create something it is the creator and not still be above that creation, is the argument. Now, some of these arguments are going to sound very appealing to some of you, and I'm not saying they shouldn't. I'm not saying they should. I'm just saying they make logical sense here as to why someone would hold this view. But it, of course, the Jeffersonian view, or the states' right view, was not the only view. There was also the Hamiltonian view, or the federal supremacy view, or the broad construction view. And the basic premises of this view I've got listed here below, so let's just go through those. So the framers knew that they couldn't foresee everything that would go wrong, everything that would happen, all the exigencies. And so they added to the Constitution the authority to, quote, make all laws which shall be necessary and proper to carry into execution the foregoing powers. This is right out of Article 1, the article that deals with legislative power and lawmaking. There it is, to make all laws. And so one of the issues that had crippled the Articles of Confederation Congress is their power was only expressly granted. If it wasn't there, there was no room to do anything other than what was expressly granted. And so to deal with that issue, they added this they added this necessary and proper clause in the Constitution to make sure that this new government would have the flexibility to act according to what was going on. Now, in addition to that, they also added the Supremacy Clause, which states that the laws, treaties made pursuant to the Constitution are the supreme law of the land. One of the issues under the Articles of Confederation were states were arguing that their law was supreme over the law of the Articles of Confederation Congress. And so you have these 13 independent states say, no, we are not bound by what the Articles of Confederation Congress does, because we are our own independent state or nation, and therefore we don't have to follow what the Articles of Confederation Congress wants, unless, of course, we think that's best. And so that created an unwieldy situation where there was almost no way that these 13 states ever acted together. And then finally, for the Hamiltonian broad construction federal supremacy view, they took a look at the historical context of what had happened. And given this economic and historical context and the other issues that gave birth to the Constitution itself, they argued that it ought to be interpreted to pursue the purposes intended. And that purpose intended was to create a government that was strong enough to control the governed. If we go back to the Madisonian dilemma, strong enough to control the government, and they sought in the Constitutional Convention to create a government that would also be obliged to control itself. But the Hamiltonian view, federal supremacy view, is basically saying to the Jeffersonian view that if we do it your way, where are we going to be? We're going to be right back in the Articles of Confederation, and this new government we created is going to put us right there, and it's going to operate the same way, even though our intent has been the opposite. So, I ask you this question. Which view is correct? Where do you stand? Are you a Jeffersonian, strict constructionist, states' rights, or are you a Hamiltonian, national right, national power broad view? Which are you? Now, it shouldn't trouble you if you don't really know. Again, I could go back to the statement that we first examined with Woodrow Wilson. Now, what we want to do is we want to go and we want to look at some of the history behind this and see how this evolved. The point of these of the broad construction or strict construction is to let you know where people were coming from with this whole debate. All right, so a little history here, still operating under this question, which view is correct. Now, I would argue, even though I have the question, which view is correct, you can argue that neither view is correct. That they're only premises from which to argue given what is happening in the United States. And then the people are deciding. And there's justifications for both sides. Justifications for both sides. And then the people have to decide, based on what's going on, which premise at that time they're going to embrace. Now, do I really think one view is correct? I kind of do think one view is correct. But the problem is, if I always went with that view would probably become too powerful. So again, in a sense, neither view is correct, though each of us have some affinity to one as opposed to the other. So now let's look at the history of what's going on, and you'll get a better idea of what I've just said. Um, when the country was first established under the Constitution, one of the things that happened was you had the development of political parties. Quite accidentally, nobody in a sense intended say, hey, we need political parties. It just happened. That's what I mean by accidentally. George Washington, as you probably already know, had warned his fellow countrymen against the baneful effects of party, as the way he said it. But parties happen nevertheless. One scholar said that actually I think it was Madison, said that political parties are as necessary to government as air is to fire. It just happens. He would have called those factions. So what happened is, as this new country begins, you get people congregating, as it were, ideologically between the Jeffersonian view and the Madisonian view. And okay, so we started talking about these parties. And in congregating around those views, the people who embraced the Jeffersonian view became known as Jefferson Democrats, and the people who embraced the Hamiltonian view became known as Federalists. In other words, they were arguing that the federal government ought to be supreme. You ought to have this broad construction to make sure the federal government is supreme. The Federalists at the time of after Washington steps down as president after 2 terms, there is a very close election between John Adams and Thomas Jefferson, and Adams ekes it out. He wins. He barely wins, but he wins nonetheless. He was a Federalist. The Federalists could see the writing on the wall, that more people were embracing Jeffersonian's view, and especially the immigrants who were coming over. And so to stave off the Jeffersonians' power, this Federalist Congress passed the Alien and Sedition Laws. So the Alien laws required that in order to become a citizen of the United States, you actually had to live here for 14 years. The Federalists were hoping that in that time that these new immigrants would, quote, see the light and become more Federalist or broad construction. And if they didn't, at least that would give the Federalists 14 years. And so they passed these Alien and Sedition laws, made it a crime to speak ill about the government or its leaders. Obviously unconstitutional. Nevertheless, this was a new country and they had the First Amendment, but they weren't used to practicing, as it were, what they necessarily had codified in law. And so because of that, because of this Alien and Sedition Act passed by Congress, Thomas Jefferson and James Madison wrote what became known as the Virginia and Kentucky Resolutions, in which they argued that the states ought to nullify or declare void laws or acts of this federal government or this national government, which in their view contradicted the Constitution. This is a big deal. This is a huge deal. If Jefferson and Madison are right and states can nullify federal law, where does that put us? It puts us right back into the Articles of Confederation, a weak and ineffective form of government. Think about that for a second, and we'll end this video and go to the next, as I only got 15 minutes on each one of these. And think about that.